Judgment in the matter of KO Nigeria and others versus Secretary of State for the Home Department.
Lord Carnwath will explain the judgment of the court.
3 of these appeals raise issues under Part 5A of the Nationality, Immigration and Asylum Act of 2002. In short, these provisions seek to give clearer guidance to immigration judges when considering whether interference with private or family rights under Article 8 of the Human Rights Convention is justified in the public interest. The cases are concerned with the effects on children. The 4th, Pereira, raises a similar issue under Rule 276 ADE 14 of the Immigration Rules. Section 117B, which is general in application, provides that the public interest does not require the person's removal if that person has a genuine and subsisting relationship with a qualifying child, and it would not be, quotes, reasonable to expect the child to leave the UK. A qualifying child is a person under 18 who is a British citizen or has lived in the UK for a continuous period of 7 years or more. Section 117C is concerned with foreign criminals as defined and provides that their deportation is generally in the public interest. There is an exception for one sentenced to less than 4 years imprisonment who has a genuine and subsisting parental relationship with a qualifying child if the effect of deportation of that person would be, quotes, unduly harsh on the child. The main issue is whether in considering these questions the tribunal is concerned only with the effect on the child, or whether, as the Secretary of State argues, it has to conduct a balancing exercise, weighing the impact on the child against the wider public interest. Although the Supreme Court does not wholly accept the Secretary of State's approach, it unanimously dismisses the appeals on their own facts, for reasons in a judgment given by myself. These provisions contain no requirement as such to consider the criminality or misconduct of a parent as a balancing factor, and in the view of the court there is no reason to imply such a requirement. However, it is relevant to consider whether the parents, apart from the relevant provisions, where they are expected to be, as it will normally be reasonable for the child to be with them. To that extent, the record of the parents may become indirectly material if it leads to them having to leave the UK. In section 117C, unduly harsh introduces a higher hurdle than that of reasonableness under section 117B. But again, it does not require a balancing of relative levels of severity of the parent's offence, other than is inherent in the distinction drawn by the section itself regarding length of sentence. Turning to the individual cases, KO and IT both concerned foreign criminals under section 117C. In KO, the Upper Tribunal judge was wrong to decide that he should take account of the criminality of the parent in applying the unduly harsh test. However, this did not in practice detract from the correctness of his reasoning applying the approach now held by us to be correct. In IT, the Court of Appeal was wrong to introduce a, quotes, compelling reasons test and to proceed on the basis that the assessment of harshness required the nature of the offending to be considered. However, the Tribunal had made other errors which justified the Court's order for remittal to the Upper Tribunal. NS was a case under section 117B. The parents had falsely claimed to have completed a postgraduate course in order to obtain leave to remain. The judge was entitled to regard the parents' conduct as relevant to the extent that it meant that they had to leave the country and to consider the position of the child on that basis. In Pereira, the Court of Appeal had ordered that the case should be remitted to the Upper Tribunal for fresh determination on the issue of proportionality. Pereira has now ceased, in fact, to be a child, and he is qualified for leave to remain under another rule, according to the Secretary of State. However, that may have other consequences, and if that is not agreed, the appeal will fall to be considered on remittal in accordance with the law as stated in this judgment. No further order is therefore required.
Court will adjourn.